Good afternoon. I'm Carl Peters, this year's president of the New Jersey Association of Professional Mediators, and I'm thrilled to be able to welcome you to the second half of NJAPM's first annual forum on cultural competency. The first half of the program, which took place on February 16th, was fast-paced and informative. Most of you here today attended the first session, but I see that a few people signed up after that program was completed. Thank you for joining us. It is our hope at NJAPM that this program will assist us all in understanding and bridging our differences. If we all need to use our best efforts to listen to each other, we can gain understanding. We need to be open to seeing that we all have different perspectives on issues based upon the things such as our age, education, experience, gender, religion, race, and more. We as mediators rely heavily on listening skills to improve communication among parties whose view of the world and the dispute that they are embroiled in often vary greatly. The failure to acknowledge cultural differences can be an impediment to resolving these disagreements. I believe that the information provided in today's program will help us all to communicate more effectively. Judge Lawrence Jones has once again assembled an impressive team of panelists for this program. Today's program is geared towards civil mediation. Before I turn the program over to Judge Jones to introduce today's speakers, I'd like to say a few words about NJAPM. The New Jersey Association of Professional Mediators is a group whose mission is to promote mediation as the preferred way to resolve disputes. We're a diverse group by gender, race, and religion, but also by professional background. Many of our members are attorneys, but we also have members who are experienced in other professions such as education, labor relations, mental health, and accounting. One of the goals of NJM is to increase the awareness by the public at large of mediation as an effective way to resolve disputes and avoid litigation. We also offer training to improve the quality of mediators. This year, we've been able to provide many webinars, some offering continuing education credits, some do not. Many are low cost, some are free. For those of you who are interested in entering the field of divorce mediation, our basic 40-hour divorce training starts on April 11th. There's still a few seats open. Registration recently opened for our basic 40-hour civil mediation training program, which starts on May 16th. We also present 2 conferences a year. We're currently planning for a spring advanced mediation program on a date tentatively set for June 4th. Details of this program will be announced next month. Our annual conference will be held in November. Both of these are to be presented online. We hope that you enjoy today's program and find it useful. If you like it, consider becoming a member of NJAPM to enable us to create more informative programming. With that said, I'll turn the program over to Judge Jones.
Thank you, President Peters, and welcome to everybody for attending today, Cultural Competency in Civil Mediation. Part 1, as President Peters indicated, was conducted last month on February 16th for family mediators. Today we're going to be concentrating on principles relative to civil mediators. The family mediation webinar is actually available through NJAPM online on its YouTube channel, and so it can be available for persons who missed it as well. We're really excited about both parts of the program because this is our inaugural year focusing on a forum for cultural competency. And cultural competency is becoming such a critical area of focus for mediators and really in all professional capacities. We live in a very heterogeneous society, people from different diverse backgrounds, and cultural competency is necessary to be able to harness all of the different talents and energies that people have from different backgrounds for a common good. So in the context of mediation, it's important for a mediator to have cultural competency when dealing with persons from 2 different persons or more from different cultures, and also perhaps having a different culture than the mediator. These are bridges which can be built and do not have to be barriers or obstacles as long as there is understanding, sensitivity, and, quote, cultural competency. So this is a key area of ongoing study for any mediator. We have a lot of good materials, and you can download the materials, various articles, an excellent article written by one of our panelists today, Tia Chang, and some other articles as well, and also a self-test for implicit and unconscious bias, which if you haven't already read it, one of our panelists today is going to be addressing that and how it works. It's a very good test to try to test yourself in terms of whether you have any implicit biases. Culture, as I stated at the first session, is not limited to nation of origin. It involves ethnicity, it involves race, it involves religion, it involves gender, age, disability, sexual orientation, multiple different backgrounds. And people from different backgrounds have different positive, constructive ways of looking at things. No two people look at the same issue the same. And as a mediator, trying to bring resolutions and settlement to people who have different views on things and maybe from different backgrounds, it's certainly a skill that you want to develop. And hopefully today will be a starting point, not an ending point, but a starting point in perhaps a lifelong journey towards ongoing cultural competency in our society. We have an excellent panel again today, and let me just briefly introduce the panel. We have Margarita Echevarria, and she's an independent arbitrator and mediator in private practice with memberships on the FINRA Commercial Arbitrator, American Arbitration Association, CPR Institute, and the Federal Courts of New Jersey and New York, and is on the 1:40 list in New Jersey Superior Court Civil and New York Commercial panel. She has more than 25 years experience in the financial services industry as either corporate counsel or chief compliance officer in New York and New Jersey. Her practical experience in commercial disputes, business loans, insurance brokerage commission, and interpleader disputes, along with construction, investment management, real property, employment wages, and personal injury, including asbestos disputes. In arbitration cases, she has served in non-administered and administered cases, either as a chief solo or wing arbitrator, and is a member of both the New York and New Jersey bar. Anju Jasani, our next panelist, MBA APM, she founded Divorce with Dignity Mediation Services in 1997, following a career in financial services. In addition to a private mediation practice with offices in Hoboken and Clinton, Anju is on the New Jersey Administrative Office of the Court's roster of family divorce, foreclosure, and business civil mediators. She's an accredited civil mediator by the New Jersey Association of Professional Mediators and an advanced practitioner member of the Association for Conflict Resolution. Anju served on the NJAPM Board of Directors previously, and she held the office of president from 2005 to 2007. And she's an instructor in both the NJAPM and the New Jersey Institute for Continuing Legal Education's 40-hour divorce mediation training program and directs the NJAPM program. Felicia Farber is a full-time ADR practitioner serving as mediator and arbitrator for the AAA state and federal courts. She mediates and arbitrates civil, commercial, and divorce matters with a concentration in employment, construction, and complex business commercial disputes. Felicia received the 2009 ADR Practitioner of the Year Boesky Award from the NJSBA and serves on the New Jersey Supreme Court Committee on CDR and Arbitration Advisory Committee and the Advisory Committee on Mediator Standards. She's the Vice President of NJAPM and serves on the Executive Committee of the Labor and Employment Section and as a trustee of the Women in Profession Section and past chair of the Dispute Resolution Section. And Felicia is also the author of the fiction book Ice Queen, which is available on Amazon, which is all the rage right now. And you may want to go out and buy it. So she's highly accomplished in many fields. Tia Chang is an independent full-time arbitrator and mediator focusing on commercial, intellectual property, IP, technology, entertainment, and employment disputes. He has been appointed to several rosters, including AAA, the CPR Institute, and the Resolute Systems. He's the president of the Justice Marie Garibaldi American Inn of Court for ADR, the immediate past chair of the New York State Bar Association Dispute Resolution Section, the treasurer of the Copyright Society, and serves on the council of the AAA. He received the 2020 James Boesky ADR Practitioner of the Year Award from the New Jersey State Bar Association Dispute Resolution Section, and the National Law Journal named him a 2017 ADR Champion. Mr. Chang also has 20 years experience as an IP and general commercial litigator. He received his A.B. cum laude in chemistry and physics from Harvard University and his J.D. from New York University School of Law. So, as I said earlier, and President Peters said earlier, we have really an outstanding panel today of people from multiple diverse backgrounds to talk about this very important issue of cultural competency. And thank you to all the panelists for appearing here today, for the audience members and for NJAPM. So we're going to get started at this point. And my first question will be for Tia. Tia, what in general is the difference between diversity and inclusion and cultural competency?
Sure. Thank you, Judge. In my view, diversity, inclusion, and cultural competence are three distinct concepts. Diversity, to me, means the presence and sometimes the celebration of of individuals of different characteristics or traits that make one person or individual different from another. And it encompasses all the ways in which people are different from each other. Inclusion, on the other hand, is establishing an environment in which those individuals will feel respected, supported, and valued. And this allows them to fully participate in the workplace or in the profession or whatever the context happens to be. Those two concepts reminds me of a famous quote from Verna Myers, who's a leading expert in the D&I space, who says that diversity is being invited to the party, inclusion is being invited to dance. Now, contrast that with cultural competence. Judge, you mentioned that culture can encompass all different kinds of characteristics. And one useful definition that comes from Professor Barkai's article, what's in the CLE materials, is that it's the total accumulation of an identifiable group's beliefs, norms, activities, institutions, and communication patterns. So then cultural competence as a concept is the ability to understand, communicate with, and effectively interact with people of different cultures. So it encompasses being aware of your own worldview, becoming aware of your own cultural assumptions and biases. It's developing positive attitudes towards other cultures and gaining knowledge of different cultures and practices and worldviews, developing skills for communicating and interacting across cultures. So as mediators, being culturally competent means being a professional who respects multiple cultural ways of knowing, seeing, living, perceiving. It means celebrating the benefits of diversity and having an ability to understand those differences. And then it means also striving to ensure that all participants, no matter what their cultural background is, are engaged and included in that mediation process.
So essentially, to have diversity and inclusion without cultural competency, or to have cultural competency without diversity and inclusion, it's like having half the ingredients for a cake. Would you agree with that?
Yeah, I might not have used that analogy, but that's exactly right. I mean, it's basically having only half of everything. It's not really encompassing what you need to encompass if you truly want to have people engaged in this process.
Okay. Anju, in follow-up to that, what's the difference between cultural competence and cultural blindness?
Thanks, Larry. And so we're looking at two sides of a coin. On competence, we're looking at knowledge and ability to interact effectively with people of different cultures. And so that means having an interest in their cultures and respecting that your vision or your lens might be different than theirs. So the cultural blindness is in a sense, the opposite of that, the idea that the minority needs to adapt to the dominant culture, not the other way around. So if you think about, for instance, scheduling an event on a Saturday, which sometimes we do because we have no choice, understanding that there's a segment of the population that cannot attend. Now, being blind to it is just saying, well, that's when we're having it, they're going to have to adapt. Understanding that sometimes you're going to have an event, but maybe you need to record it so that people who can't attend on the Saturday can watch it on a Sunday if you can't do it on a Sunday. So I'll give you an example in our training. Right now, we're doing our 40-hour training, and because we have the flexibility not to do it over weekends, we're doing it on Sundays to really enlarge the pie of people who can attend. And there are lots of different things this applies to it, whether it involves medications made with certain substances or scheduling, or even understanding that sometimes there are cultures where conflict is not a comfortable thing and people might need to caucus. Sometimes a person who's younger may not in a certain culture feel like they can oppose an elderly person's viewpoint because that's disrespectful, and to provide a forum where each person can provide their point of view. So the blindness is the opposite of cultural competence, where we just assume that people should do things our way.
And so if you have cultural competency, but also cultural blindness, what could be the negative consequences of that?
I mean, ultimately, if you as a mediator have that, you're going to have a situation where you may be alienating the client. You may not, you may be impeding a settlement by you as the mediator not acknowledging or accommodating the needs of the clients. And I think that's why we're holding these sessions. One is to have mediation have a larger outreach to the community, and then to become more competent mediators.
So in terms of tools on how to do that, beginning tools on how to assess, your level of cultural competency, or the term implicit biases, what type of tools are available?
Okay, so there are different tools that are available, and some of them test implicit biases versus explicit biases. And I think that there is a difference. I can tell you that I'm not racist, or but sometimes what we say versus what we feel inside can be very different. And so we have tools. The best tool for implicit bias is the Harvard tool. And I'm going to bring it up on my screen to share that with you. Is that okay? Okay, let's do that. Well, first of all, I'm going to show you a result, which is kind of interesting. I took the result for gay and straight people, and this is an interesting test because it asks you, first of all, demographics, and then you're asked to press different buttons on what's good or bad. And interestingly, it said I have a preference for gay people over straight people. Now, I'm not sure that's a bias, but I thought that was an interesting result. I'm going to also bring up the test if I can. And the Harvard test is a test that takes about 10 minutes for each section. And it is, it asks questions on a wide variety of topics, including disability, transgender, skin tone, weight, age, race, gender, and it can be found on Implicit Harvard EDU. We had sent this in the material, so if you have an interest in doing the test yourself, you can do that. I'm gonna, give me a second and I'll click that to bring it up. Is that okay? Because
yeah.
Let me see if I can bring that up. Okay. So are you seeing in your screen Project Implicit now?
Yeah.
Okay. All right, so you should be seeing the screen now.
Okay, yes.
Project Implicit, right? And they ask if you wish to proceed. And now you can take tests on various areas. So let's take the one, sexuality. And you're continuing to see me click through these, right?
Yes.
I'm not embarrassed to put my year of birth in, so it's. And at this point, I've taken 3 to 5 tests. I'm probably slightly liberal, and I'm not religious. Now, I have no idea the algorithms that are used in this, but they must have demographics on zip codes and your age and so forth. You can see I've taken the test before because I know how to. I just put legal in. Nope, that's not management. That's fine. So, okay. So I guess I'm supposed to put. And so you click either E or I, depending on, oops. So, okay. So you go through this test and you keep clicking, and there are about 40 of these. And at the end, you get some type of rating. So it's kind of fun to do. And there are skeptics on this test, but I think even taking the test gives you a perspective on how quickly you respond. Because first of all, they have, for instance, gay and good, then gay being bad. And you have to click, I think it measures how quickly you respond and answer the question correctly or click the right E or I. How many of you have in the panel have taken this test?
I mean, if I may, I'll just say that this is a test. The algorithm of the test is designed to measure your response time relative to certain words that are put up or sometimes pictures that are put up. And by measuring the response time, it tends to give you an indicator of whether or not you have a particular bias or an assumption about a particular group. Now, it's not foolproof. If you take the test many, many times, you can actually game the system. But you may be surprised if you do the test, all the kinds of biases or assumptions that you may have in that you may not have even realized. And because it measures implicit biases, it's exactly that. It's things that you're not consciously aware of, but are potentially influencing your behavior and or your perception of things. And that's why it's important as mediators to be at least sensitive and aware to this topic, because it could happen. It could be happening in your mediations.
So I would say that I was kind of surprised at the results of taking 3 of the tests. So I took the sexuality test, I took skin color test, and I took disability tests. And it said I actually had a preference for gay, I had a preference for dark skin, and I had a slight preference for ability over disability. So what does this mean, or how am I going to interact? I think it makes you more self-aware if you're in a certain group. Certainly if I'm with a group of people who might have some type of disability, trying to be more mindful of how I interact with a group, maybe being more conscientious, being more careful, and being more kind. And so people ask when you take these implicit tests, well, what do you do as a result of that? And that's when you have to become more mindful, especially if you feel like you have a certain bias that might affect your ability to be neutral in a certain session or setting. So that's the implicit test. And then there are explicit tests. And the one that I like is the Greater Vancouver Multicultural Society Cultural Test. And this is one where you just assess how interested you are in other cultures and so forth. And I can bring that up on the screen. And I really recommend that mediators try and take both these tests, because this is a situation of learning more about yourself and becoming more self-aware. You lose nothing by taking the tests.
So in follow up to that, and the need to be self-aware. So Margie, what's really, if you had to sum it up, what's the difference between explicit and implicit bias in simple terms by a mediator? And can you provide a hypothetical example of how such biases could negatively impact a mediation if you're unaware of them yourself?
Sure. Implicit bias, as was explained earlier, are unconscious beliefs and attitudes that we have about other social groups or cultural groups. And they may even include stereotypes or associating special traits with these social groups, as opposed to explicit bias, which are feelings and attitudes that we have, that we are aware of, and that we express in language and or actions.
So essentially, if it's implicit or unconscious, you those could potentially be more impactful in a negative way because the mediator doesn't even know they have them.
That's exactly right. And that's why the suggestion that Andrew just made about taking those implicit association tests are helpful, because they make you more sensitive to your implicit biases. I wouldn't recommend taking them many, many times, as Theo indicated, because you would probably game the system. But you know, a couple of times, the first time because you'll probably be shocked at whatever your implicit bias is, and then the second time to sort of like check. I did that with the race association test. I haven't taken any other, but I think as we've all indicated, that taking those tests tells us something about ourselves that can be useful when we're mediating.
Now, could I share the other test with you, the Vancouver test?
Sure.
So if you look at the cultural competency test, it's a checklist. I value human difference as positive and a cause for celebration. And you check off never, sometimes, occasionally, often. And I know myself, I share my culture, and so forth. Now, again, I think you can definitely beat the system by answering often to all of them. But if you're honest with yourself, you will also try and get an honest assessment of where you are.
And Anju and Margie, I believe you had a short video on implicit bias. Is that available, or is it not available?
I'm gonna share that. So
okay. Okay, do you want to share it now or later on?
Can you see the screen?
Yes.
Okay.
The sound is off, Andrew. Andrew, the sound of the video has to go on. Can you hear it? Yes. Okay. All right. Okay. Thank you. All right. So Felicia, let me turn to you at this point. So what are microaggressions? We hear this word used a lot. Some people know what it is, some people don't, but what is it essentially? And how can it impact a mediator's role?
Microaggressions are unintentional slights, indignities, put downs, and insults that marginalized people experience every day. They're not new, but now we have this name for them. Microaggressions can be intentional or unintentional, and sometimes even well-meaning, but they communicate hostile, derogatory, or negative messages or assumptions to the receiver. Sometimes well-intentioned people can say rude or insensitive things that demean a person's heritage or identity. And this can happen to any of us as mediators. which is why we have to be particularly aware and sensitive, to microaggressions. I'm going to give you some statements to illustrate what they are, and I want you to think about whether these examples are innocent and harmless, or whether they have hidden messages and can be derogatory or demeaning. So keep in mind that with a microaggression, what is said and that intent and the impact of what's heard are two different things. So we'll start with some verbal microaggressions, because microaggressions can be verbal, nonverbal, environmental, or they could be facial. You could have facial microexpressions. So for verbal, if someone says, "You speak English really well," and they meant it as a compliment, well, the person who's receiving that might think that if they're a foreigner, they're being told that they're not smart, or maybe that they're not a real American. So they're not taking it as a compliment. The statement, "You don't look like a lawyer," that's something that I think many women attorneys of color, and minorities have heard. I could tell you this is something that I have heard over the years many times. I have an engineering background, and countless times I heard, "You don't look like an engineer, you don't look like a lawyer." Oh, what do I say to that? That kind of, to me, is a little bit insulting, and it's not something that you could say, "Oh, thank you." Other types of verbal microaggressions are you mixed race? Were you born here? Where are you from? No. Where are you really from? Your family, your ancestors? You don't look Jewish. I didn't know you were Muslim. So again, doesn't matter how these were intended, it's how they were received, because communication is two ways. The message that's being sent and the message received. And in microaggressions, the message received is not positive. So there can be verbal microaggressions as well that I mentioned. And they could also be microaggressions by exclusion. For instance, if you leave somebody out, excuse me. If you leave somebody out of a meeting, don't include them in your email chain. You cross the street if you don't like the way somebody looks. You reach into your back pocket to make sure your wallet is still there, or you hold your purse tighter. Those are all kinds of non-verbal microaggressions. Environmental ones are, let's say you have a bumper sticker on your car that could be offensive to people, political signs on your lawn, hanging the Confederate flag on your house, or using an American Indian mascot name for your team. Facial micro expressions are visual signals, facial cues that might not match the words that you're saying or the message that you're sending. So you want your words and tone and your facial expressions to be aligned as a mediator. Otherwise, you could be having credibility and trust issues. So it's really important that your words match your expressions. So what's being conveyed with micro expressions are these messages and the examples that I gave for the people receiving them, is that you don't belong, you don't fit in, and they can make people feel really alienated or different and have powerful detrimental consequences. And that's not something that you want to occur in your mediation. So if it does arise, how do you address it? So in caucus, I would ask, why do you think it was appropriate to say that? Would you say that to everyone? What led you to make that assumption? Because there's a lot of assumptions that are behind these microaggressions. Why do you feel comfortable saying that? And remember, what could be really small or subtle to one person can be really big to somebody else. So we as mediators especially need to be aware that our words and actions, have potentially different meanings to somebody else.
Okay. What I'd like to do is to go through some hypothetical situations that a civil mediator may come across during the course of trying to resolve any type of civil matter in the realm of cultural competency, and kind of pick everyone's brain and how you might approach the situation, and vice versa, people in the audience. So, Theo, if I could start with you. So, say you're mediating a case, culturally competent mediators mediating a case. So what might a mediator do when the customs of a party in his or her nation of origin might differ radically from the legal rights in the United States or applicable state? I mean, you could say, well, we're here in the United States, so this is what governs, but you have to be sensitive as well. So you might have this type of dynamic. It may come up. So what can you do to handle the matter in a culturally sensitive and competent way?
Well, I think I can best answer that question with an example because it's actually happened to me. I had a mediation in which the plaintiff, it's an employment case. Plaintiff was a doorman working in a high-rise building, but he was an immigrant from Ghana. And during one portion of the mediation, this plaintiff decided to retell what happened on a particular day. But it became obvious that the retelling was very difficult for both me and the other side to actually understand, because he was telling the story not in a linear way. Most of us understand facts and historical narratives in a linear fashion. And the way in which this was coming out, the way we like to hear things is because of the linear fashion, we view those facts historically and then apply the law to find out what the legal rights and obligations are. That's a very standard Western way, US way of looking at things. But I had done some research in advance because I knew the plaintiff had come from Ghana. And I realized that in that culture, people of that culture actually view time very differently. The Ghanaian culture actually is a polychronic time culture, which means that they actually view time as fluid. And so where many things can be done at the same time, simultaneously. That does not need to mean that they're all, experts at multitasking, but the fact is that polychronic cultures value relationships over tasks. And so their whole conception of time is relational as opposed to linear. And once I recognized that that was what was going on in the way that that person was telling the story, I clued in counsel on both sides that was happening in caucus situations. And by doing that, I was able to get them to understand what was going on and help them get past this particular point in the mediation and then move on to other matters. So in the end, I was doing what all mediators should be doing, which is to facilitate communication between the parties by recognizing that there was a cultural impediment based on this person's background. And by being sensitive to that party's need to tell his or her story in the way that was consistent with his culture and his cultural paradigm, that can ameliorate, communication style differences that can impede mediation. And I think that if you don't take the time to do that in a mediation, you're going to run into what Professor Barkay actually calls in his article the Popeye problem. Popeye the Sailor is someone who says, I am what I am, and that's all that I am. And the problem with that is that because we are US mediators with an American legal system as the backdrop, we communicate in a way that makes it very difficult for us to necessarily communicate in ways that other cultures don't. And so if you don't take the time to understand what these other cultures are, you're going to end up as other folks have said already, you can alienate other people. You can end up misinterpreting and misunderstanding what's happening in the mediation. So that's what I would take the time to do, which is to make sure that if there is some kind of cultural issue that's at stake or an issue in a mediation, to be aware of them and then try and do some preliminary research on that so that you can prepare yourself for the mediation.
So let me ask you a follow-up question in that hypothetical, or perhaps not so much a hypothetical because it was a real life situation. In terms of doing the research, this person, for example, came from Ghana in this scenario. Does the mediator do research on the culture in Ghana before the mediation actually begins, or after an issue actually is raised in the context of mediation with the specific person involved?
Oh, preferably before, but my practice is that if I recognize that there might be a cultural issue, I may recognize that from the pleadings in the case. I may recognize that during the pre-mediation call with counsel. I'll immediately just ask the counsel. I'll say, where is your client from? What cultural background does your client hail from? Is that something I need to be concerned about? You know, is there some issue here? And I may do this in a private call, an ex parte call with the council too. But I would suggest that doing that kind of research in advance is always preferable to doing it on the fly, number one, because then you're better prepared. But of course, you can't prepare for everything. If something does occur in the mediation, always take the time. You know, Andrew said, be mindful, and that's exactly what you should do. You should take the time to take a break for yourself and see whether or not you need to do that research at that moment or even after the session is over, so you can get back to people and make sure that having had the time to reflect on what happened, you might be able to provide better insight to the parties.
If it's
Larry?
relevant to a specific issue. to a specific-
Exactly.
Larry, let me give the first
Yes.
attendance code. So
Yes.
the first code is 4697. 4697.
Thank you, Carl. All right, so Felicia, let me ask you a hypothetical. So suppose you're mediating a case, a civil case involving two strangers from entirely different cultures, neither of which is your culture. So you have three different cultures. You have the mediator's culture and the two parties' culture. So what are some practical tips on how a culturally competent mediator should begin to proceed in that type of scenario?
So this is actually a very likely scenario in real life because the US Census Bureau reports that in 2019, 23.4% of New Jersey's population was born in a foreign country, and in our neighbor New York, 22.4%. And if you're curious, the state with the largest foreign-born population is California, which was almost 27%. And nationally, we have around 45 million people living in the US who were born in a foreign country with over 350 languages spoken. So as mediators, we need to recognize the needs and individuality of each of these people that are coming into our mediation room. What are their values, their beliefs, and mediation may be a very unfamiliar process to them and nothing like they're used to. So for ourselves, we need to begin by doing our own bias check. Anju is giving you some resources that are available to do a check, you know, a general check online. But with respect to the particular cultures that have come before you, you need to make sure that you have no explicit biases against any of these cultures. And keep in mind that we are human beings, so all of us have biases, and that's why you do the implicit bias test to try and uncover any of the ones that you're not consciously aware of. The good news is, though, that biases are not set in stone. Studies have shown that prejudice is fluid and people can change it. So in fact, when people from opposite sides are put together, they start to see the other side as human because they discover that they have things in common, they're not so different, and recognizing their common elements of one another can transcend the conflict and open the door to resolution. So you want to educate yourself, and Theo started to speak about this. So you need to understand the people that you're helping and how they negotiate in their culture. What are their communication patterns and styles? Are they typically very formal, aggressive, reserved? In the materials that we've provided, there's a reference to an international study where 83% of Americans that were interviewed felt that they had an informal negotiating style compared to 54% of Chinese negotiators and 53% of Spanish negotiators. But on negotiating attitudes, 82% of the Chinese negotiators described their style as win-win, while only 44% of Spanish negotiators did. So you can learn also from friends or colleagues who are from that culture. And if you don't know anybody personally, then you could expand your circle and ask other professional colleagues if they're familiar with these cultures and see if they can give you any practical info on cultural norms and customs and whether they have any insights into how negotiating works in that culture. And if you still can't find somebody from that culture or someone who has experience working with people from that culture, then reach out to members of other peer groups and professional organizations like NJAPM, the Inn of Court, the State Bar Association. Specialty bar associations are a great resource, the ABA dispute resolution section. Having a network to tap into is another reason why it's so important to be affiliated with your professional communities. You need to do research online. There's really no excuse for not reading up on a culture and learning as much as you can, because it's really easy now. And of course, there's books and journals, studies that can be additional resources. And once you're knowledgeable and you demonstrate your cultural awareness to the people, the participants in your mediation, then you're going to be showing respect for them and for their culture. So before the mediation, this has also been said, and I'm just going to emphasize that before the mediation, that's when you really want to try and get to know the parties and get an understanding of them and their culture better. Talk to them, ask them about their case, make small talk and build rapport so that they can start to trust you. And if they don't speak freely, which could be a function of their personality or their culture, then frame open-ended questions so you can understand their background and values. You know, say things like, tell me, how have you resolved disputes before? Have you ever been in a mediation? You know, get them talking and get them comfortable. So you're going to use this pre-mediation consultation to explore cultural issues and to educate one another. And since it'll be just you and the other party, they should be more relaxed and feel more comfortable than they would if their adversary were present at the mediation session. Use your mediation active listening skills. Listen to their responses, be attuned to their body language, and watch their reactions. How are they reacting to each other? You need to read the room. How are they reacting to you? Are cross-cultural issues causing a problem in the mediation? You need to be sensitive to not only what they're saying, but to their nonverbal communication as well. And a major part of our communication is our body language, our tone of voice, gestures, eye contact, our posture, all of that. And in preparing for this program today, I learned that in American culture, something as simple as the thumbs up hand gesture, you know, is good. We approve of something, but you know, that same gesture in South America or in Arab cultures can have a vulgar meaning. You know, so the more you educate yourself, the better it will be for you and all of your participants.
Right, so
Another thing to consider if there is any
okay.
cultural dynamics going on is the empty chair syndrome, which the person who's not in that mediation can have a very powerful impact on the person who is there and who might not feel comfortable making decisions on their own. So you need to feel this out in advance if there's somebody that they're accountable to who's not present. You know, can they make concessions to resolve the case on their own, or do they need to save face with their family, their constituents at work, board members, or people in their organization? Maybe from their culture, you know, they're not going to be comfortable in a joint session, or maybe they only want a joint session. So these are things that you want to find out in advance. And as mediators, our goal is to really increase their mutual understanding of each other and between us.
Right. So even something like the cultural significance of a handshake. In some cultures, for example, men and women don't shake hands, right?
That's
you may
right.
think you're being very, very, pleasant at a first meeting in the first 5 seconds, and you could potentially alienate or offend somebody right off the bat if you haven't done your homework, right?
Yeah, so I've had many people come before me from Asia, and they bow to me, not it wasn't something I was familiar with at first, and so I didn't know what to do. So, you know, the first couple of times it happened to me, I nodded my head back at them, and then I looked it up. You know, what do I do? And it turned out that is a sign of respect and honor, and no, you're not supposed to bow back to them. So
yeah. It's always learning. And follow up to that. So Anju, let me ask this. Let's suppose you do all your homework. You've taken the self-test. You've done your research. You've done everything that Theo and Felicia and Margie have advised. and you still somehow find out during the course of the mediation, despite all of your good intentions and doing your homework, that you have offended someone culturally as a mediator for whatever reason, even though it was not your intent. What then do you do at that moment? How do you acknowledge it? Do you not acknowledge it? What advice can you give those who are listening in terms of a logical way to handle that type of awkward situation?
Well, first of all, it's going to happen because there's so many nuances to culture. You can't possibly know everything unless you're raised in that culture. And as a tidbit, I was born and raised in England, and we moved here when I was 12. So I've never lived in India, but whenever we went back to India, my mother would give us, 3,000 ground rules that we would still break, because we just were not raised in that culture, right? So, for instance, you're supposed to respect an elder by trying to touch their feet. Well, I'm not touching anyone's feet, right? That's what we said as kids. I can see Theo laughing because there was probably something similar in his culture, right? So when you just don't know, and sometimes things are uncomfortable. So if you do offend someone, I think first of it, use it as a learning experience because you really don't want to do it again. And apologize, but you don't need to overdo it. I think you need to apologize and explain it was done intentionally. And you can even ask if there's anything else that you should be aware of so that you don't put your foot in your mouth and that you're effective. And I had a list in the handout of things that could be unintentional. For instance, in German dealings, if you move your chair closer to someone, that's considered an insult, right? But a lot of times you may, in a meeting in US culture, move closer to say something, not to be heard by someone else or to make a point. And so there's a million subtleties that you may not be aware of, no matter how much you read, that you're going to make a mistake on, and use it as a learning experience. So I do think it's good to do that reading, but you have to be careful because you may make an assumption. I read about Indian people, and so you will giving them, the namaste rather than shaking hands. But they're second or third generation, and they're wondering, why are you doing that to them? I'm a business person. I'm an MBA. I shake hands. So there's so many subtleties in that I think sometimes you have to take someone's lead, see what they do first, and follow their lead.
So essentially, there could be a risk if you overgeneralize or overassume something about somebody's adherence to particular cultural norms just because they're from that culture, that not only might it not match up with their own individual preferences, but it could actually be a form of stereotyping, correct?
I think exactly that. Felicia talked about people saying, oh, you speak such good English. I laugh when people say that to me. I mean, I was born in England. I have never lived in India. I was raised with the Queen's English, quite frankly, whether that's good or bad. So when I'm told that I speak, I don't speak English well, but they say, oh, you speak good, or what? I just have to say, but I view it with a sense of kindness too. I look at it in the intention because it's meant as a compliment. And so that's also something that we can also learn as individuals, how to react when the intention is positive, but it comes across wrong.
Right.
And I think when you apologize, you can also say that I really meant it as a compliment. I didn't mean to insult you.
Okay. So Margie, in follow up to something Felicia was saying concerning a hypothetical situation when other family members are involved or people don't want to make decisions sometimes because of, whether they're embarrassed for other members of their family or whatnot. So assume a hypothetical case where you're mediating a civil case and it appears to you that culturally speaking, the parties before you, the decisions which are ultimately being made are made by persons who are not in the room or persons who are not parties to the case, but who have influence over one or both parties, family members, family elders, religious community members, friends, interpreters, whatever it may be. So how should a mediator handle that situation? Do you allow non-parties to participate in the mediation? Do they have any role in this? Or are they simply kept out of the mix because they are not parties?
I've actually had the experience in a couple of cases where non-parties were present at the mediation. In fact, I could think of two cases that I volunteer for the Southern District of New York Federal Court where non-parties were present. And it was helpful. I found it that my inclination is more towards inclusivity with regard to these non-parties. In these particular two cases, one was an insurance interpleader case. The other was a business-to-business dispute involving theft of services. The non-parties were younger members of the family who were fully bilingual in English and in Spanish. And so the effect of their participation in the mediation was to reduce stress for the more Spanish dominant members of the family that were involved in the dispute, that were the disputing parties. They also, because they were fully bilingual, lifted the power imbalance. So the Spanish dominant individuals felt that there was somebody in the room that understood everything that was going on and were assisting them with their mediation. A third aspect of it, which affirmed my inclination towards inclusivity, was the strengthening of the team support, so that the reduction of stress and the strengthening of the team support kept them at the table, continuing to negotiate, which is what you as a mediator want. You want folks to continue to negotiate and communicate to reach a resolution in the matter. So I don't think of it as a negative. I think of it as a positive.
So in follow-up to that, and I'll put this out, Margie, to you as well as the rest of the panel, because this situation comes up. We talked about it a bit in the family law panel as well. Sometimes it comes up in divorces, it can come up in a civil matter. If for example, one of two parties is clearly being influenced or dependent on culturally what somebody else who's not in the room has to say, and it might make sense to involve that decision maker or influencer because it may help settle the case, but it may not help settle the case too, because that person may have a negative influence in the whole process. Maybe they're kind of, maybe they should mind their own business to some degree on certain issues, right? But more importantly, the other side might not agree. The other side might not want some other person in the middle of their business. So you may have this mix of well, different interests or different different desires by one party or the other in terms of who gets to participate in this process for cultural reasons, especially if the two parties perhaps come from very different cultures. So as the mediator, how do you case manage that to a conclusion that might work for both sides, where you're giving everybody the best of all possibilities rather than having a procedural dispute before getting to the merits of the issue? I'll put this out to Margie as well as to anyone else on the panel who's had that type of situation.
Well, I welcome others' comments on it, but my reaction is that if that person who has that influence is not in the room, then there's not too much of an impact that person is bringing to bear, hopefully. Even if not being in the room, let's say conversely, they do have a lot of impact, well, then it behooves you to understand with the parties that are impacted by that third party, what the influence is, and understand it, what the cultural impact is, so that you can, in caucus, explain that the person that's in the room is the one with the responsibility to make a determination and make a decision ultimately, and hopefully that will help you resolve the matter.
Any other thoughts on that from the panelists?
So Woody Mostyn, who is a very good mediation trainer, talks about Snow White and the idea of inviting all the witches to the table. And so asking at the start of the mediation, are there any other decision makers who should be included in the process? And even if you don't invite them into the room, allowing breaks where people can confer with those people. Right. And I think that while Woody teaches more on the family side than the civil side, it's really the same thing. We ask at the beginning, are the decision makers in the room on a civil side, right? That's one of the first things you're taught when you do full mediation training. And so it's really the same thought. It's not so much a cultural issue. It's really an issue that applies to all mediations. Who are the decision makers or who are the people who will have an impact or can in that decision? So that's what we have to be aware of as mediators in every case, it's not really a cultural issue. It's a general.
And then in the context, I guess Zoom makes it a little easier to some degree because people could go into separate breakout rooms. If there's a relative or friend, someone lives with a parent or brother, or whatever, they could just have them pop on if the other side so agrees, for that to happen. And you'd still have to have confidentiality agreements, I'd assume, or something like that, because you have non-parties now participating in a confidential process.
And
definitely, in fact, in the Southern District of New York cases, you require all the parties to sign the confidentiality agreement, whether they're parties or not.
Right. So if you're talking, good rule of thumb there in this type of situation, if a mediator is involving other people because for cultural reasons or really even for any reason, to make sure you have the confidentiality preserved with signatures, etc. Very good point.
I think I'll just add one quick thought is that I agree with everything that's been said so far. But I also think that when you have influencers involved who are non-parties, you also have the potential problem of ratification of any consummated deal. And so you want them somehow involved. They don't necessarily have to always be in the room with the parties. They can be in a separate room, or as you noted, Judge, they could be in a separate breakout room on Zoom. But if you fail to involve them in some way, and I like what Margie said before, which is to probe a little bit as to what extent this person has that influence and what is the nature of that influence, and then try and convince the other party who might be objecting that there's a reason why that non-party ought to be involved. Because if you don't have that ratification later, that deal won't be durable in the end anyway.
Right. So sometimes
I just want to add to that it's so important to have full transparency. You need to make sure that the other side knows who else is participating in the mediation and that they approve that they authorize that if it is going to be online or in person. And again, I had touched on this when I spoke earlier about that empty chair syndrome and saving face. Who is that person accountable to that's not there? And that can be so important. Otherwise, even if the person does feel comfortable entering into a resolution at the mediation, it could torpedo afterwards. That other person could destroy it. So it's really important to ask these questions and to be fully upfront. So I agree.
You have to be careful with these online that person isn't lurking. There are some mediators who do a 360-degree view, ask the participants of the room, which I won't do, but I think it's an issue that, there may be people you're not aware of who are in the room.
Right. Yeah. That's why it's kind of helpful when you have mediation agreements to have a representation by each side signed within the agreement that especially if you're doing it by Zoom, that they will not have anybody else in the room or within earshot, so that at least there's some accountability in the event that that's violated. People may violate it anyway, that there's no way to completely control that with a guarantee, but at least you have the upfront representation that that's not what's supposed to happen.
Right. You act on the honor system, and I have included remote mediation terms in my agreement now that we're operating remotely, and I would recommend that everybody do that. So you're asking that nobody who's not identified be present in the mediation, and especially if you're having arbitrations, you don't want anybody who's off screen coaching the person that's there. I have a provision that it is not to be recorded, in any manner at all, that it's a private proceeding. So you reinforce that, when you speak in your mediation opening, but you also have that in your mediation confidentiality agreement. So, there's no question that those are the ground rules for the mediation.
Right. So Felicia, if you have let's say you have a multi-session mediation, just expanding the hypothetical we were just talking about. Sometimes these mediations, you can't get it done in one session. And it appears in a session that as things are going on, that cultural issues and concerns are more of an issue than what was originally anticipated. You found out at the beginning of the case, you spoke with, for example, with the 2-attorney case, you spoke with both attorneys. It didn't seem to be major cultural issues or concerns that are at the heart of the case. And as you're going through the case, you find out, you learn by the end of session 1 that it is in fact a very prevalent issue in the context of the mediation. So what do you do in between sessions at that point? How do you address this if you're starting to see that cultural issues are in fact paramount in resolving the matter?
The first thing I'm going to do is speak to the parties separately and find out what their thoughts are. They have to be comfortable with the process and feel safe at the mediation, and it's my job as the mediator to make sure this is a fair and just process for everybody. And that won't be the case if they don't feel that the mediation is a safe space. Maybe there was a microaggression that I, as a mediator, didn't pick up on, a comment or remark that was taken as derogatory or discriminatory, even if it wasn't meant that way. By speaking with them separately, I can find that out and learn the extent of the microaggression's impact. And this is important because if they felt demeaned in any way, then the mediation is not going to be a comfortable environment for them. If there was nothing blatant that happened, but I sensed a disconnect or an awkwardness in the room, I'm going to ask them if there was anything at the prior sessions that happened that concerned them. Part of my job as a mediator is to gauge the comfort of the participants and the flow and the tone of the mediation. So I'm going to try and get some more specific information out of them. And by being open and candid, showing them that I care about how they're doing, I can learn if there's anything else that they need me to do or that they want the other side to stop doing. And feelings, they say feelings are fact, because feelings are so important. And if they were offended or insulted, it'll be really hard to be productive if they can't get past a slight. If there was something said or conduct that was exhibited by a party or counsel that showed prejudice or that appeared to be bias motivated or disrespectful, I'm not going to ignore it as if it didn't happen, because it did happen, and it's my job as the mediator to provide a quality process, and I don't want that diminished. Also, if I don't acknowledge it, then I'm showing that I think the comment or action was okay with me or that it was irrelevant. So I'm not going to be a passive bystander. I'm going to intercede and acknowledge the problem and address it. So every situation is different, and no matter what, as a mediator, I need to appear impartial and not to seem to be helping or favoring one party over the other. So I have to consider whether it's best to intervene at that moment or to wait. I could take a break, I could speak to a party separately during that time, or in caucus, or potentially adjourn the mediation. To the person on the receiving end of any inappropriate conduct, I'm going to ask them how they would like to move forward and get their suggestions. I want them to feel invested in the process and to understand that their opinions and preferences matter. So I want their input. Now, what am I going to say to a person that said or did something that can be construed as offensive or insensitive? I'm not going to call them out at the mediation or lecture them. I'm going to ask them, again, privately, questions that make them think about their actions, such as, have you noticed how he reacts when you say he was lazy or didn't fit in? Or what do you think he's thinking when you say that? Or how do you think that makes her feel when you talk that way? And then hopefully they'll come to the realization that what they said is inappropriate and they can't conduct themselves that way. So if cultural barriers are apparent, I think it's really important to address them in order to get past them. There was a time in my career when I worked for the state of New Jersey Office of Dispute Settlement, and I did over 3,000 foreclosure mediations. So I've had many, many people from different cultures come before me. And I recall one instance, a woman from India was just sitting at the mediation table and she wouldn't say a word the whole time. If anyone asked her a question, she looked at her attorney to answer. And I didn't know if it was personal or cultural reasons, but when I spoke to her privately in caucus, it was the same thing. When I asked her if she wanted to speak, she shook her head. When I asked if there was anything I could do to make her feel more comfortable, she shook her head. And when I explained to her that her participation was very important to formulating an outcome that worked for her, that's when she finally spoke. And she said, "That attorney is lying. Everything he said is not true." So that ended up being not being cultural. It was just she was seething and with her teeth gritted together so tightly that she couldn't even talk. And then now I'm going to give you an example of another situation that was very culturally dependent in a foreclosure mediation with a man from Korea. He was going to lose his home because his arrears were astronomical and his salary was too low to qualify for a loan modification. So his only way out of the financial mess was to file for bankruptcy, but he refused to even entertain it as an option, although there was no other way out of his predicament. And I spoke with his attorney in between the mediation sessions, and he explained that in this culture, there was a strong stigma associated with bankruptcy, and this gentleman would rather lose his home than file for bankruptcy. And it made no logical sense to me because he was already in foreclosure, which carried a pretty significant stigma. But I had to respect the fact that in his way of thinking, in his culture, the bankruptcy was more negative than the foreclosure.
So in follow-up to that, and Margie, let me ask you this. In follow-up to what Felicia just said, and the need for a mediator to effectively adapt to cultural expectations of parties in mediation. Some people feel you can use forms, for example, to gather information. Some people have different ways of preparing. What are your feelings on that? What would be the most effective ways, some of the effective ways a mediator can meet the reasonable expectations, the cultural expectations of the parties, besides simply, reading general books about whatever their culture may be?
There's a variety of things that you can do as a mediator to address the cultural expectations of the parties. You mentioned intake forms. That's a really viable method to get information about whether there's going to be, in fact, any cultural variable that will be significant in that mediation. Besides asking about language, there are questions that you can ask, and I believe that in the materials that we're going to be providing the attendees, there are sample intake forms. I think it's already been mentioned as well that consulting with the attorneys for your clients will surface whether a cultural variable is going to be significant. And all of these things, the intake form, consulting with the attorneys, is all about preparing for the mediation. That's one of the more core activities that a mediator can do to have a successful mediation, is to prepare in advance. It's not just knowing the legal ramifications, the pluses and minuses from a legal perspective of what's at play in the mediation, but it's also understanding the psychological and or cultural or economic issues that impact the discussion. Thirdly, mediators use consultants all the time in mediations. Think about medical injury cases where you need a doctor as an expert consultant on a mediation. So by the same token, using a cultural consultant might be helpful. Learning, in the cases that Felicia just mentioned, if she had used a cultural consultant, or if one was available, they might have clued her in to, what was going on with the Indian lady beforehand, and or the Korean foreclosure client. I myself have used a consultant, a cultural consultant, so to speak, in a case involving an employer-employee dispute because I wasn't particularly familiar with that subgroup of the Hispanic culture. And so I wanted to learn and be sure when I attended that mediation that the Spanish I spoke didn't offend in any way, shape, or form, or also to understand any hierarchical nuances because it was an employer-employee dispute in that mediation. So there's a variety of things you could do. Intake forms, consultants, the attorneys.
So for example, to follow up with the cultural consultant concept. So in a hypothetical case, if you're going to contact a cultural consultant, what specifically would that cultural consultant do? I mean, they're not just serving as an interpreter or a translator, they're actually advising the mediator on certain things they perhaps should keep an eye on. Is that correct?
That's true. In the literature that I've reviewed, one example given was of a Filipino wrongful death case where the cultural consultant came in to explain the importance of the person that had died was a 25-year-old Filipino woman and the eldest daughter in the family. So the cultural consultant, for example, explained how important it was that she was to the retirement of her parents, so to speak, that they would be relying on her for the financial support that she could provide. So that explanation helped with setting economic damages and understanding other damages like pain and suffering, et cetera, that were involved in that case. So you can call on cultural consultants for that are trained or understand that culture and can explain that in the mediation. As I did with regard to the Hispanic group that I needed a cultural consultant on.
So
And one of the footnote with regard to Hispanic, the Hispanic community that I wanted to share with the group to increase cultural competence here is that Hispanic, the use of the term Hispanic is a cultural construct in the United States. And it's an umbrella term to cover a large group of Hispanic groups in the United States that share one common language, Spanish, but that don't necessarily share cultural norms, traditions, or even idiosyncratic versions of Spanish. So that's why, for me, it was important to consult a cultural consultant in an employer-employee case so that I didn't say anything in Spanish that would be offensive to the group.
And then Anju, and follow up to what Margie just said, particularly on the issue of forms, because I know that some of your sample forms are included in the materials. And the question comes up if you're developing forms, questionnaires, what you perhaps should or should not ask or how you should ask it without, offending anybody. What are your thoughts on that concerning the development of intake forms in order to enhance cultural awareness and cultural competency in any particular case? Pros and cons type.
So after our initial conversations with Joni, I actually felt it was a really relevant issue. And so on my family side, I added a question: is there any information regarding your ethnicity, cultural identity, faith, religion, sexual orientation, language, disability that you can provide that will help with the mediation process? Now, Raj said these are almost irrelevant. Once you start the mediation or you meet the parties, you can answer that question to some degree, or you can ask them that. And so far, no one has filled in anything on my intake form regarding that. So this is a work in progress, but I still think even if they don't answer it, what it says to them is, you're thinking about me and how to make the mediation process better for me. So if they need to bring it up, they will. I was interested in what Margie said about her story with the Filipino woman. And I think what it gets back to is if we ask the right questions or we allow the clients to tell their story enough, we may get the information we need. But oftentimes we conduct the mediation as cross-examination with a yes, no, or we have such directed questions rather than using an open-ended question about, for instance, what is your inability to work? How does that impact your family? And I really want to understand all the people that might be impacted by your inability to be able to provide income. And so, working backwards, it gives you the right questions to ask. So we need to let people tell their stories. In mediation training, I'm often interested in people who have a strong legal background, and they don't have that. They don't do that because they don't want to ask a question they don't know the answer to. But that's what we need to be able to do as mediators in the process, get them talking and get them to storytell.
Okay. So along those lines, and we touched on this a little bit earlier when we talked about the risk of overgeneralizing or stereotyping. Tia, how does a mediator practice cultural competency without overgeneralizing, without putting people in general categories for their preparation to the point of unintentionally stereotyping them in the name of cultural competency?
Yeah, that's a really tricky dilemma. Like, I think it's important to recognize that stereotypes and generalizations of different cultures are existent within each of us to some degree. I mean, it's part of our upbringing, it's part of our socialization. And, sometimes those things are helpful, but oftentimes it can be that stereotypes and generalizations can cloud our perspectives, and it can color our judgments about people. So, what are supposed to be complex and dynamic and diverse situations often end up, being boiled down to like really simple formulas for us in our own brains. And it's really akin to the same problem that confronts us with implicit biases. It's the same problem that Daniel Kahneman talks about in Thinking Fast and Slow about System 1 and System 2. And, so in a cross-cultural context, I think it's important to sort of take the time to unpack those stereotypes and use them to inform ourselves about our own culture and our own perspectives, and recognize, how our own biases and possible stereotypes of others may be in some way misguiding you, misinfluencing you. It's the same thing that, for example, arbitrators should always be doing to guard against confirmation bias, when they think they know what the answer is, but are not fully appreciating what the other side is saying or arguing. And I think, one way to do that is to engage in mindfulness. I'm not talking about mindful meditation, but mindfulness about what you're doing. Be thoughtful and engage in self-reflection. Go slow and check in with yourself. When you feel like you're making generalizations about a particular individual in your mediation, hang out in the middle of your bouncing between rooms, right? Hang out in some place that's of your own. Like, oftentimes when I hold a mediation, well, now I do it via Zoom, but even on Zoom, you can create a separate breakout room just for you, the mediator. And I just go hang out there by myself to sort of take a moment to reflect and take some space for myself. When I do it in person, I'll try and go down the hall somewhere away from the other parties and make sure and check in with myself to make sure I'm not engaging in overgeneralizing or stereotyping of someone, that my words and conduct are not being misinfluenced by those stereotypes. And also, many of the techniques that people use to help override implicit bias, like behavior replacement and individuation, will likely be helpful, because again, it's exactly similar to the problem that you have when you have over-reliance on System 1 that Daniel Kahneman talks about. It's the immediate, easy solution to problems to go to stereotypes and try and put someone into a box, rather than taking the time to be alert and see whether or not you actually are engaging in some sort of stereotyping that might be, frankly, a disservice to the mediation participants.
Now, the concept of the mediator setting up a breakout room just for themselves, I haven't heard of that before. That's probably a pretty good idea in every case.
Because
you need a break, you just go into your own little breakout room.
What I used to do is just use the main room, right, where people are in their separate breakout rooms, and I just go back to the main room. The one party I just left thinks I'm going to the other breakout room, but I'm actually hanging out in the main room. But the problem with that is that if someone drops out of a breakout room and they dial back in, they'll dial back right into the main session with me. So now I actually set up a separate breakout room so I can hide out there for a little bit before I go into someone else's breakout room, and no one's the wiser that you've taken that time for yourself.
Interesting idea. Felicia, let me come back to you. there's been an enhanced focus and increased focus in this past year due to national events and such on the concept of anti-racism. So in the context of civil mediation and cultural competency, what is anti-racism and what's the mediator's role, what they need to be aware of relative to anti-racism?
All right, thank you. Well, first I'd like to say that last year, the violent deaths of people like George Floyd, Breonna Taylor, Ahmaud Arbery, and the deep-seated social unrest that followed forced the United States to confront structural and systemic racism. The legal profession and alternative dispute resolution field were not immune, and my remarks today are against this backdrop. In order to understand anti-racism, we need to first understand what racism is. The dictionary definition is a belief that race is a fundamental determinant of human traits and capacities, and that racial differences produce an inherent superiority of a particular race. And Margie mentioned previously the Hispanic social construct, and racism is also a social construct, which is a class distinction that has been created, accepted, and cultivated by the people in our society. So these constructs don't exist naturally, but they're created by human beings. Another example of a social construct is anti-Semitism, the discrimination, prejudice, or hostility toward Jews. Anti-Semitism is generally considered to be a form of racism as well. Another concept I want to introduce is coded language. Coded language is where there are layers of meaning. It's language that triggers racial stereotypes and other negative associations without the stigma of explicit racism. Examples of terms that carry racist connotations are thug, making reference to a Black man, grit, referring to students of color, or a leader saying, I talk to the community, meaning a racial minority or socioeconomically challenged group. Last week in the news, there was a judge in Kansas who was suspended from the bench for things like dropping F-bombs, but for also calling athletes Kansas boys. And the judge says it was a geographical reference, not racial, but it was perceived as racial. As mediators, we need to recognize that the ways racial tensions and bias can surface in our mediations and understand skills that we can use to navigate these tensions. So if you learn of potential difficulties before an in-person session, then use the pre-mediation meetings to address them. If you're in the mediation room, ask yourself, do you see anyone with actual or apparent bias? And if you do, then what? And the answer is to ask questions and to talk through difficult situations. I think the best approach is to directly address this issue. For example, let's say there was an allegation by a company that a person showed poor teamwork. Was that coded language being used, potentially racist? Remember, we talked about microaggressions. So was it an innuendo that was meant to be offensive, or was it understood as offensive or malicious? And a way of finding out as the mediator is to ask questions such as, when you said poor teamwork, what did you mean by that? You know, give the parties a chance to clarify and explain and address the impact right there. So you could ask the employer, what does the company normally do to address poor teamwork? Were steps made to include this person? What were those steps? And to the employee, you could ask, you could give them the opportunity to describe their claims more fully if they're saying that they didn't fit in. Because remember that there are feelings and emotions behind these claims. So you could ask them open-ended questions like, how do you feel about the claim that you're bringing? And if they say that they didn't feel valued or they didn't fit in, you know, say, well, what do you mean by valued or fit in? So you keep going, you keep following up so that you neutralize and diffuse the situation that surfaced. So at the outset, I think it's really helpful to find common interests and beliefs between the different people in your room, and that can minimize the impact of unconscious bias. One study found that whites at a Stanford football game answered simple requests from other whites far more often than from African Americans. But when the African Americans wore shirts with Stanford on them and they approached the whites who wore Stanford shirts, they got more help than the whites without the insignia. And this shows that by creating a new group, the one wearing the Stanford shirts, the prejudicial impact was eliminated. So we as mediators can learn from this lesson, and we can engage our participants and try to, if we think that there might be bias or racism present, we can try to redefine the groups that they belong to, from race or religion or any ethnic background or sexual orientation. We can redefine them into new ones that eliminate or reduce the bias by drawing out the similarities from the parties. Maybe they discover that they both have kids in college, they like the same baseball teams, or they want to go to Hawaii when the pandemic is over. Whatever it shows, whatever you do that shows that they have common elements and similarities. And then last, if you feel that you have done everything that you can, and there still might be some problems there, you could think about maybe co-mediating with somebody else that has similar background and characteristics to the mediation participants.
Okay. We're going to be wrapping up shortly. We're going to leave some time for some questions. I know there's some questions in the chat we'll go through. Tio, for particularly for the newer mediators who are coming in, maybe they haven't been mediating that long, and students, people in the mediation course who are going to be taking it this year, how, in your view, can students and new mediators be adequately trained moving forward in cultural competency beyond a program, an introductory program such as this one?
Oh, absolutely. Well, as everyone knows, the basic 40-hour mediation courses generally nationwide only touch upon cultural competency just for a few minutes of that 40 hours. So I highly recommend that you seek out advanced training in mediation on this particular subject. There are plenty of one-off advanced mediation courses that are out there. For those who are members of the National Academy of Distinguished Neutrals, they may remember that back in 2019, at their training retreat, Nia Meyerding, who I highly recommend, is someone who's a negotiation and mediation trainer coming out of Seattle. She has a specialty focus in gender and culture in mediation. So any one of her courses would be terrific. But also there are private companies that offer a number of these kinds of advanced courses. The Bridges Academy has a certification program on intercultural competence. IMI, the International Mediation Institute, also offers a certification in intercultural competence. Higher education institutions also offer a lot of cultural competency type courses. For example, business schools who teach in cross-border negotiation courses will always incorporate cultural competency as part of those courses. So you may be able to take those or audit them. And there are also some online courses, believe it or not, that you can just, spot courses you can take for free just by looking online. But, I want to go back to what you said, Judge Jones, at the very beginning of this program. You said that cultural competency is something that's an ongoing educational thing for mediators, and I wholeheartedly agree. It's not a one and done kind of thing. I would encourage everyone really to be a lifelong learner on this subject and always continue to be open-minded and expand your skill sets and your toolkits, by developing your cross-cultural competency skills.
Yeah, totally agree. All right, before there are any,
let me give
yes,
this
go ahead, Carl, the second
the
code.
second
Yes.
code, which is 3654. 3654. And let me also mention, I had an internet failure for a few minutes. There were some questions that had been posted that disappeared when I came back. So there may be some other questions out there that people might want to re-ask.
Okay, thank you, Carl. We before our panelists give their final thoughts, we're going to look at some questions here. And let's see what we have here. Bruce asks the question, can you say more about how one's culture impacts their sense-making and thereby their actions and the formation of intentions, positions, and preferences that may lead to conflict? Anyone want to take that? I'm not quite sure what the question means. Can you say more about how one's culture impacts their sense-making? I guess in a general sense, how one's culture generally impacts one's thinking, actions, and the formation of intentions that may lead to conflict. Anyone?
Well, let me
Go
just,
ahead,
I know that Bruce left the meeting, but depending on the culture you come from, it could be conflict adverse, it could be more open. It could be that some cultures like a large, loud, boisterous argument where others shy away from it and shy away from culture. But these are just one variable, and we have to be careful that we don't think that everyone who comes from a particular culture is going to behave based on that stereotype. So, you know, whether it's, you know, the issue of eye contact, we may have that view that, you know, Japanese people don't want to think it's rude to have eye contact, but someone else, you know, might be an exception. Just like if we had a stereotype on Americans based on how Larry Jones behaved at a certain meeting, that all Americans behave like Larry Jones.
I'm looking at the questions, and some of them are comments, and we appreciate that as well. There are two questions here in particular I think are really good, which we did not specifically address, but should be relevant really to any practicing mediator. The first one is, how do you as a mediator handle a situation where one of the parties displays explicit bias towards you? And the second kind of related question is, how do you deal with counsel who are exhibiting bias? So one is the bias is coming from the party, and assume a case perhaps doesn't have counsel. And the second is, what if you have an attorney who's exhibiting bias really towards anyone, essentially? So these types of issues clearly can come up in any case on any given day. So in the mediator's toolkit, culturally competent toolkit, how do you prepare in advance for those types of situations? Tio, any thoughts on that?
Sure. I mean, I think with respect to bias against the mediator, I think it depends on, first of all, whether it's hostile or not. Obviously, if it's hostile, then, you know, we have a situation that maybe that the mediation is falling apart because I'm not fulfilling what the party wants me to do. And I may take a moment to ask, is there something I'm doing that's upsetting you? Is there something that you want me to change about the way I'm conducting this mediation process that will make it better for you? If it's hostile, if it's not hostile, then I think I would go back to me as a person. Look, I'm a person of color. I lived in this society for decades now. I've been the victim of a lot of, you know, incidents of racial bias too. You know, you can't react every single time someone throws an epithet at me. I think you have to kind of ask yourself whether it bothers you enough that it's going to impede your ability to be the guardian of the process and continue conducting the process in that impartial, fair manner. If it does, then you have to take time to extricate yourself from that situation, or at least give yourself a cooling off period. If it doesn't, and you just let it kind of brush off, which is most of the time what happens to me, then I just move on, and I just kind of move on, forget about it. With respect to parties or counsel exhibiting bias generally in the mediation, if I think it's impeding the process in some way, I'll do it. I think it was Felicia who said this before. You might take that person, you know, or persons in a caucus situation and say, you know, do you think that what you're saying here or how you're acting here is helpful in the process? Or how do you think it's helpful to continue the dialogue with the other side by your saying these things or conducting yourself in this manner? And see if that person will recognize that the conduct or the words that they're saying is actually not helping the process at all, not leading to a collaborative potential agreement between the parties.
Felicia, Margie, and Anju, any follow-up thoughts on that? You have bias coming at you from either, let's say it's explicit bias, from either a party or an attorney in the room. You know, how do you address it in a way which doesn't undermine the mediation process, but which keeps the integrity of the process? at the level it's supposed to be.
So let me,
Again,
on
oh,
the-
sorry, go ahead.
I would
I would try.
where it is. If it's at the beginning of the mediation, it's one thing. If you're 9/10 through and you're close to a resolution, is there a benefit to addressing it or ignoring it? And if you at that point focus on you versus the resolution, are you benefiting the client? So I think it depends a lot of times when it occurs, but that's my perspective. That is it helping to come to the resolution that the parties say they want a resolution, and because I don't want to focus on my ego. And with that, I'll turn it over to Margie.
Yeah, I was gonna, more or less, I was going to, in the same direction. I would deal with the offending counsel or party in a separate room, because we're all Zooming these days, and ask them whether their behavior is encouraging resolution in this particular case, or ignore it if I can and deal with it afterwards. Share, the time to meet with this person afterwards and explain to them how that behavior is not conducive to the ultimate goal that presumably all the parties in the room have, which is to reach a resolution. In fact, one of the things that I do now is I provide a document, a guide to the council, and sort of like prime the fact that they should be gearing towards compromises. A lot of times today, our mediations turn into adversarial forums, and that's not the whole point of mediation. So I would bring them back to the guidance that I gave them to begin with, that their mindset should not be a warrior mindset, which is what I tell them. It should be a compromise mindset. That's what we're here to do. We're here to reach a mutually satisfactory resolution for the parties.
Felicia?
Well, basically, everything I was going to say has already been mentioned. So just as mediators, we ask our questions, ask open-ended questions to try and get to the root of the problem and find out where the discontent is coming from.
Okay, I see we're past the time we were supposed to conclude. So I'm going to ask if each of you could just give a short final thought, final comment, parting words of advice or wisdom for those in the audience concerning, the concept of cultural competency and how to really make it part of your life. Andre?
So I go back to the idea that you should know thyself and put yourself in being the other in the room and see how it feels, because if we're used to being accepted or being part of what's the norm, we don't know what it's like when we're the outsider. And so if we do that, it'll make us more mindful as we're in the room where someone else is an outsider. And not to take offense when people unintentionally insult you, and to learn from your mistakes. Apologize when you're wrong. I think finally, I also want to say that people need to speak up if they're involved in an organization or in programming, or you're putting a brochure together and it looks like it's not a diverse brochure. Who are you trying to appeal to? Because in our actions and in the organizations we work in, we need to push towards greater diversity, because we're trying to reach, especially as mediators, a larger audience. And so and I know the bar is doing that now with presentations, wanting to have more diverse speakers. I mean, it's a diverse speakers of value. Obviously, it's not just having people who are filling a slot, but we oftentimes invite people that we know.
Whoops, I think Andre froze there.
Yeah.
Okay.
Let me
Sorry.
say,
Yeah,
let me
Margie.
say, with regard to last words, we are mediators. We are guided by the model standards of conduct, and central to our role as mediators is our impartiality, which means freedom from bias, favoritism, and prejudice. So that is the mindset that we go into mediations with, and that we should retain throughout the entire process. It makes our clients or the participants trust us right? When we are acting impartially, even-handedly, equally with respect to the parties, and allows the mediation to become effective. I would submit to you that if you don't have the trust of the parties, you will not have an effective mediation.
Felicia?
There were two statements in the materials that I found to be extremely profound and compelling. The first is, one culture is not better than the others. And I took this and substituted culture with race, religion, ethnicity, and any of the things that humans rely on to declare their superiority. Religion is not better. One religion is not better than the others. One race is not better than the others. And the second statement that was also poignant was, chopsticks are not better than silverware, nor is it essential that one culture learns to use the utensils of another. And it's up to us as mediators to destigmatize the difference.
Words. Tia?
I'll just add something or take off on something that Andrew said, which is to know thyself. As much as it's important to research other cultures, it's important to know about your own cultural norms and how that can affect how you view things and how you conduct and say things at the mediation. So once you understand a little better about where you come from, you can then be in a position to better understand where other people are coming from.
And if I could add in my final 2 seconds of thoughts on here, no matter what culture you're dealing with, patience and kindness can usually do the trick and get you pretty far in mediation and in dispute resolution. I want to thank everybody for participating. I want to thank President Peters. I want to thank our technical director, Carl Cangelosi, and everyone behind the scenes at NJAPM for helping bring into reality this two-part series. We hope to do this every year and grow it and expand upon it, perhaps work with some other organizations. And if anyone out there is interested in being involved with cultural competency through NJAPM, just notify us, drop us a letter. We hope you enjoyed the program, both parts of the program. You can get your diversity and inclusion credits by submitting the appropriate forms. And best of luck to everybody. Take care. Have an excellent day.
Thank you, everybody.
Thanks, everyone.
Bye.
Bye.